Welcome everyone to the next installment of our interview series on career paths in international arbitration. Our second session today will focus on what it's like to join a third-party funder. And we have Olivia Furter, who is the co-head of Switzerland, France, and Benelux at Nivalian, being interviewed today by one of our very own members, Francesca Borio, who is an associate at Valdervis. If anyone has a question, please raise your hand via the Zoom button and turn on your camera. You will have a chance to ask questions at the end, but we want the format of these sessions to be conversational. So please feel free to ask your question during the interview as well. Without further ado, let me hand this over to you, Francesca.
Thank you, Paula, for the kind introduction. Good afternoon, everyone, and welcome to the second interview session. Before we start the interview, I would like to make a brief introduction to third-party funding, because perhaps not everyone is familiar with it. Nivalian supports parties in the pursuit of their high-value arbitration and litigation by underwriting all costs of the proceedings, including all the costs of the proceedings arising when a claim fails. Nivalian's investments are non-recourse. This means that Nivalian only receives a share of the proceeds if the claim holder wins the claim and if the claim can be successfully enforced. If the case is lost, Nivalian loses the investment. Nivalian further offers monetizing claims, financing portfolios of disputes, and financing selected defense cases. Now, with that in mind, let's turn to Olivia. Olivia, tell us a little bit about yourself and your career so far.
Sure, and hi everyone. And thank you, Francesca, for this kind introduction of Nivalian and what we do. I think that's maybe helpful for everyone. And so, yeah, sure, I will try to give you a brief overview of my path to here. Maybe I start with my academic background. I studied law and economics at the University of St. Gallen. My initial plan was to just study economics, but I fell in love with the law during the first semester. So that's why I switched to the major law and economics, which was rather new at the time in St. Gallen. I then did my trainee year at Niedere Kraft und Frey in Zurich. I don't know if someone is maybe working at Niedere Kraft und Frey. And I was there randomly placed in the private clients team. So I didn't choose, they just put me there. And I got to work on some big inheritance dispute litigations. And I found that extremely exciting. And so that's basically how I figured out that I wanted to work in dispute resolution. So after passing the bar exam, I joined Schellenberg Wittmer, and I worked there for a total of about 5 years in the dispute resolution team. So in litigation, arbitration, private clients. And then in 2019, I joined Nivalian, first in the role as case manager, then senior case manager. And since this year, I am co-head for the markets, Switzerland, France, and Benelux, as was mentioned. So, and that's where we are now.
Congratulations for your impressive career so far, and also for your recent promotion. So you're at Nivalian now. Why did you decide to pursue a career working in a third-party funder? How did that opportunity come to you?
Well, how did that opportunity come to me? I would say it was a bit of combination of, as it often is, chance, luck, and a bit of destiny. So what I didn't mention before is I also did an LLM at King's College in London after 3 years at Schellenberg. And I focused on arbitration classes, but as I am still and always was a bit interested in financials and numbers, I also took a class which was called Quantitative and Analytical Methods for Lawyers. So what we did there is we learned to look at the commercial side of disputes. So for example, we did a bit of statistic, how to calculate chances of success of a case. And we also learned how to calculate when it makes commercially more sense to settle a dispute than to continue litigation, even though you would eventually win. So we looked at present value of money. We learned that, you know, sometimes it's better to take less money now than more in the future, because you can invest this money now, and so you end up better. And I found this class extremely interesting, of practical relevance, but I didn't think at the time that I would get to use that a lot in my work. And I went back to Schellenberg, and I worked, one of the first cases I worked on was together with Isabel Berger, and she was a counsel at Schellenberg at the time. And then after a short while, she told me that she had decided to leave SV and join a funder, so namely Nivalion. And at that time, I haven't heard or known much about third-party funding, and especially not in Switzerland. But all she told me sounded, you know, a lot like what we learned in this LLM class. So I found that interesting. And we kept in touch. She always told me that she liked it a lot. And about a year later, Nivalion was looking for a case manager, and I decided to join. And so I would say, chance in the sense that I knew Isabel and learned of Nivalion, luck in the sense that they were looking for someone just at the time when I was ready to switch jobs, and then a bit of destiny in the sense that this funding allows me to use my interest and experience of both like financials, commercial sides, and the law.
That is indeed a really nice combination of these three elements. I think it's also, as you said, it's often like this, you receive an opportunity when you least expect it, and it turns out to be really
absolutely
great. So now we talked about how you ended up at Nivalion. Perhaps we can turn to the work you do at Nivalion. You said that, well, before you were a case manager, now you are the co-head of the markets. Perhaps you can talk a bit about what a typical day looks like in both positions and what the differences are between the two.
Sure, of course. And I will start with the case manager role, because the tasks are also largely the same if you're a market head. So I will just then add some additional tasks. And I have to start by mentioning that, you know, the days can be very, very different. They look very different. So maybe it's more helpful if I talk about the typical tasks you do while assessing a case, so through the cycle of looking at the case and a particular day. And so as a case manager, you usually get approached with a funding request by an attorney who is in charge of a case, or in case of corporate clients, by experienced in-house counsel. And you then ask them to, you know, talk a bit about the case and give you an overview of the legal and factual background of the case. And you try to get or do a rather high level assessment at this stage of whether you think this case could be suitable for funding or not. And if you think it is suitable, you focus on the financials first. So as a case manager, you prepare a commercial offer, so our pricing, and you usually do this pricing yourself. I mean, we have tools that help us do that, but sometimes the pricing is more complex because, for example, you do a portfolio funding, so multiple cases financed together. And in this case, when it gets very complex, we can also rely on the help of the people working in our financial department. So you're not completely on your own there, but we mostly do it ourselves. And so if the claim holder accepts our offer, that's when we start our internal due diligence phase, and we go a lot deeper in assessing the case. So we really look at the file and the evidence. It depends what we look at, what's there. So sometimes you already have a draft of a statement of claim or legal briefs. Sometimes you have an extensive lawyer memorandum. Sometimes you just have a first brief memorandum, and then you also look at the evidence. You then prepare questions for the attorneys or the claim holders, which, you know, help you understand better what's relevant or help you to assess the chances of success of the case. And then what's important to mention is that in the course of our internal due diligence, we usually also mandate external specialists for some very crucial specific questions. So it could be sometimes the damage amount is very difficult to calculate, but it's very crucial for us, to know what's the damage amount we can expect. So we would mandate and work with an external quantum expert to help us assess whether that's reasonable. Sometimes if there is a very specific, crucial question in a specific field of law that we are not specialized in, we would mandate an external lawyer to help us look at this particular question. And sometimes we have to talk to asset tracers. So we work with external specialists as well. And then if we come to the conclusion that we would recommend a case for funding, we start drafting an investment proposal. So the reason behind that is that we have two committees that eventually decide whether a case gets funded or not. And so we prepare this proposal to them in which we describe the case, the legal and factual background, as well as the commercials. And if a case actually gets funded, as a case manager, you keep track of the progress of the case. You keep a close eye on the budget. So you want to make sure that there are no budget overruns, and you get involved, of course, and the attorney informs you if there are unexpected turns to the proceedings or something new strategic to consider. But it's a rather high level review of how the case is going. So we're not keeping very involved in, what exactly the attorneys are doing. We trust the attorneys there, of course. Yeah, I would say that's about the typical work, the typical tasks you have as a case manager working for a funder. And then as a market area head, I mean, that's also the main task, to assess cases and decide whether you recommend them for funding. And then I now have some additional tasks. One is that I'm a member of one of the committees which decides whether a case gets funded. I do a bit more of business and product development. We do the budget planning for our markets. You have to do a bit more, strategic or considerations, like also think about allocation of risks within Nivolion's portfolio. So make sure not all cases entail the exact same risk. So I would say those are the additional tasks.
Okay, that sounds really interesting. It's also quite a versatile job, and it's nice to see how you can use the skills you learned in your LLM also in practice.
Yeah.
I see there is a hand by Rupa. Rupa, do you have a question?
Yes, just a related question. So how much external marketing or engagement do you have to do to get the cases to be funded, or do they just kind of come in through the door because Nivolion is well known in the market, or how does that work?
We have to do a bit of, especially, I mean, Switzerland is the headquarters, so by now I would say it's more commonly known, but we went to most of the big law firms and did presentations, and we contact some companies where we think it could be interesting for them. So it's not like cases just fly in, or at least not the very good ones. So we do a lot of business development. I think by now the concept is quite broadly known, but still we continue. I mean, I will talk about this a bit later. I would say it's still a new and growing industry. We come up with new products that are maybe not yet known, and so there's a lot of work we do trying to get people to know more and understand more about what we do and what we offer and how that could be helpful to them. Does that answer the question?
Yes, absolutely. Thank you.
Thank you.
And then I see there is a question from Alexander.
Yes, thank you. I'm wondering, because I think you've now mentioned twice new products and product development, and my first thought was, I mean, your product seems to be pretty straightforward. You know, you sort of fund the case and you receive money in returns. So I was wondering what spectrum of products, I guess, are you developing?
I mean, the quite obvious thing that you are thinking about is a single active case, meaning you are a claim holder, you have a claim, and we finance that. But and that's the typical, and it will always be, I guess, the most relevant product that we offer. But you can also think, and we have financed, I think, one big of those, defense funding. So it's less straightforward if you are the defendant in the case, because you will not end up getting money. So, and we're usually paid out of that. But so there's still ways how you have to be a bit creative in finding solutions. But if there's maybe another anchor asset from which we could get paid eventually, it could also work out that we finance a defense case. There's portfolio funding. So that's especially interesting for companies that have a lot of different cases, which means we bundle them together and finance multiple cases as one package, because that can be, we can maybe make better, financially more attractive offers, because we also have a diversification of risks within those different cases, or we could include a case that would otherwise by itself maybe not be of interest to us. So just to mention a few things. And yeah, we try to come up with new things that are helpful and useful for the market.
And I see there is also a question from Dilber.
Yeah, sorry, Francesca. I'll try to be quick, but this
no,
is
don't worry. That's what this session is for.
I just had to ask, Olivia, I can understand in a market like Switzerland or France, where lawyers are not allowed to work on contingency fees, where your business model, you know, the model of a third-party funder is needed, and I can see the necessity for that. But how do you market in countries like the US, where lawyers can take on cases on the basis of contingency fees, and you know, maybe claimants are interested in doing that as well? Is that sort of, you know, are lawyers your competitors in these markets, or?
I mean, to a certain extent, but quite often lawyers are also happy if they don't have to take the entire risk. So, because for them as well, they never know if the case actually wins. So usually they are also happy if they don't have to do the entire work for free in case the case is lost. So we have quite a lot of cases where it's both. It's the lawyers that take a share of the risk, but there's also a funder. So meaning we would pay them a certain share, like 50% of their fees or something. So they get that for sure, and they work on a contingency basis on the rest. And so quite often funders and lawyers work together in those situations. But it's less relevant in my markets because, yeah, as you mentioned, it's not possible here to the full extent.
Anna, that was also a good question. Now we talked a bit about the work at Nivalian in general. Perhaps now we can talk a bit about your personal experiences at Nivalian. For instance, what do you particularly like about your job, and what are the challenges that you face?
What I particularly like, and it's something we already touched upon before, is that I think it's still a rather new business and growing industry. So you kind of can be a bit creative and bring new ideas in with regard to new users, new markets, potential users, potential products. We were recently coming up with a new pricing model for inheritance disputes. So it has a bit of a, you know, like startup spirit to it. I like that. Substance-wise, I like that we look at the cases a bit different than I did when I was working in a law firm as an attorney. I mean, on one hand, it's a bit more high level. We don't get into the cases as deep, of course, as the attorney who is in charge of the case. But on the other hand, we really look at the case from a lot of different angles, also on the commercial side, and we really think it through from the beginning to the end. And as you mentioned in the introduction, the end is not a favorable court decision. It is actual enforcement and collection of assets, because we only get paid if the claim holder actually receives the monies. So we might have to talk to an asset tracer or think about asset tracing right from the start. And I think that that's quite interesting. I like that we get to work with people with very different backgrounds and from different jurisdictions, both within the funder as well as with regard to the outside people we work with. But that's, of course, something you also have in a bigger law firm, so it's not completely different there. So I would say those are the biggest things I like. And do you also want me to talk about the challenges, or?
Yes, perhaps let's take the question from Claudia first, and then.
Yeah, sure.
Great. Thank you. Thank you so much, Olivia. This is super interesting. And I'm actually wondering, because obviously enforcement is crucial. So I'm wondering, do you have separate procedures, for example, for purely commercial cases as opposed to investment treaty arbitrations?
We have, well, to answer that, we have someone very specialized in investment treaty arbitration, and we are a bit more reluctant with those cases. I think they're more difficult to get funding for those because you always have challenges. And I mean, we have to be very careful when thinking about who is the defendant. Will it be possible to actually get the assets? So, I mean, investment treaty arbitration is a bit more complex and a bit more rare that we actually fund them. But we have a specialist who really is experienced with those, and yeah, she usually looks at the cases.
Makes sense. That's why I was wondering.
Yeah, no, you're completely right about that.
So yeah, what are the challenges you face in your job?
I mean, the biggest challenge is getting good cases and dealing with risk, because the obvious, if a case is an obvious winner, first of all, there are not many of those cases, as you probably all know. I mean, not too many cases where you're absolutely sure you will win. And even if there is one like that, the claim holder will probably try to avoid needing funding because you pay, or he would at least not be willing to pay as much for it. And so that means our business basically is risk. We know that some of the cases will lose and we will lose our investment. So the challenging thing you think about every day is, how much risk can we take? How much risk should we take? If you're too conservative, you're not funding any cases, you're not doing business. But if you're taking too much risk, it's not going to work out either. So I guess that's the main challenge that we face.
Perhaps I assume.
I just thought I think there's a question in the chat, right?
Yes, I think this goes quite nicely with what you just said about the risk. What is
the smallest?
Jorge asked us, yes, what is the smallest value of the case you would take?
We say this is usually the minimum amount in dispute is around 7.5 million. That's like the principle that we say. Of course, sometimes if a case is quite straightforward or extremely good chances of success, it could also be a bit less. But it certainly doesn't, funding usually, at least for us, doesn't make sense if the amount in dispute is too small, because it's important for us that the claim holder always receives the major share of the proceeds. So we don't want to be the funder that, the case is won, but we take everything. So, and so if we need to take a certain share, because we also have a lot of internal work, we work with external specialists. So it's important that there is a certain amount in dispute to make sure both parties are happy in the end.
Yeah, that makes sense.
7 million.
I mean, if you yeah, the tasks mentioned before, it's quite a lot of work, so it makes sense that the dispute needs to have a certain value. Yeah. Yes, I mean, now you are working at Nivalion now. Before that, you said you worked at Schellenberg. Where do you see the advantages and disadvantages working at a law firm as opposed to working at Nivalion?
I will maybe start with what I miss. And I would say, I mean, hearings in state court litigations, especially also in arbitration proceedings, hearings are extremely exciting. And I, of course, miss those. But I have to say that even in my work in the law firm, and I guess that's mostly the case in big law firms, hearings are, well, they were rather small share of my actual work because, you know, a lot of cases settle or the proceedings take years and you have one hearing and all the rest is written submission. So I think that's maybe not relevant. I also really like the drafting of actual briefs and you know, sitting down and drafting the statement of claim or something. So I miss that a bit as well. But I would say there are other very interesting tasks in my current job which make up for it. So for example, the commercial side and all of that. What I really don't miss, and what I would say is the biggest advantage in my current position, is I don't have to think about billable hours. So I guess many of you can relate to that. I just get to work without having to write down everything I do and, you know, write down how long it took me to draft this email. And then another thing that is also quite convenient in this job is, you know, there's usually this one super specific, crucial question that, you know, keeps you up at night as the attorney in charge of the case. And quite often that's the question we can mandate an external specialist for. So that can be quite convenient as well.
That sounds really good. And I think a lot of people can relate to the billable hour issue.
Yeah, it's a small thing, but still such a big relief if you don't have to do that all the time.
And if you keep comparing the two jobs in terms of work-life balance, hierarchy, time pressure, what are the differences?
With regard to hierarchy, I don't see a big difference. I mean, flat hierarchy, both in and good work atmosphere in the law firms I worked for, as well as at Nivalion. With regard to the workload, the funding business, unfortunately, it's also not a 9-to-5 job. It can be quite a lot of work at times, but I would say there's less time pressure than in a law firm. And that is because, you know, the funding process takes a bit of time. So it's usually a matter of a couple of weeks. So it's less important whether you do the work today or tomorrow. So you're usually quite free to decide when exactly you do the work. I mean, we try to progress all the cases as quickly as possible, certainly, but we don't really have, you know, a client in the law firm. You have a client calling and saying, I need an answer by tomorrow, or you have a decision coming in and a short appeal deadline, and you just need to start working, even though you had, I don't know, something planned for the next week. So I would say it's very rare that you would have to cancel an evening appointment because very unexpectedly you need to work very long hours. Usually you can just do it the next day then. So I would say it's a bit better with regard to time pressure, and you're more flexible.
That's the big advantage.
Yeah, and maybe also to mention, I'm the co-head, so that means I'm doing it in a job sharing. And because I have 2 very small children. I actually just got back from my second maternity leave on Monday. And my great colleague, Franziska, she also has small children. And so this job sharing allows us to be a bit more flexible in the allocation of work and travels. And that's very good with an eye to our families. And I think that's something that's maybe easier to do at the funder than in a law firm, because quite often clients, they just always want to talk to the same person. So they would be less happy if, you know, one day it's this partner and the other day the other. And so that's maybe an advantage as well with regard to work-life balance in a funder.
That's true. Sounds a bit more flexible. I hope you had a good start on Monday.
I did, thank you.
We have another question from the audience, from Zil. And the question is regarding conflicts of interest. So you mentioned that third-party funding was uncommon and unknown in Switzerland when you first joined. And you also mentioned that you worked at a law firm.
To me, I'm not saying other people had. I didn't know much about it. Yeah, sorry.
To me as well. You also mentioned that you worked at a law firm before joining a funder. With disclosure requirements becoming largely mandatory, what should lawyers who join third-party funders be mindful of with regard to conflicts of interest? Are there any other ethical considerations that you are generally mindful of?
I mean, yeah, in the beginning, when you joined the funder, when I joined from the law firm, of course, we could not, you know, fund a party who was on the other side of a dispute that I had worked on, for example, or Schellenberg had worked on when I was working for Schellenberg, because I would have insider knowledge, you know, about the weaknesses of this case. So we couldn't or wouldn't fund this case. That's clear. But after a while, you're no longer involved in those cases. So there are the usual things. For example, in arbitration, you want to make, or quite often we think it's recommendable, if not mandatory, quite often it's mandatory that the funder is disclosed, just to make sure that there are no close connections between the funder, for example, and the arbitrator, because you don't want to have a conflict of interest there. You don't want to risk that an award can eventually not be enforced because of a conflict of interest that wasn't known or not disclosed. So, I mean, that's something you have to keep in mind. So close personal connections between any parties of the dispute, and especially including an arbitrator. And other ethical considerations we keep in mind. I mean, yes, we have guidelines about what cases we do not want to fund, and with view to reputational risks and our own standards. So there are quite a lot of things we just do not want to fund. There are certain, of course, sanctioned parties. We would never fund cases there, and with huge or with ESG considerations, we keep that in mind as well. I hope that answered the question.
Okay. Now, you said, well, we were talking about conflicts of interest, and perhaps that's a good way to move to our next series of topics, which is, if you want to work at a third-party funder, what kind of working requirements do you need to fulfill? Do you need a particular set of experience to work there?
Well, I think previous work experience as a litigation arbitration practitioner certainly is helpful, because all the experience you have is helpful to assess the chance of success, and especially to spot red flags, because that's the big thing that we do. And quite often those red flags are of procedural nature. So not necessarily things you read in the textbook during university, but things you experienced yourself, how long cases can take, or things like that. But I'm not saying that you necessarily need many years, because if you work in a law firm, the longer you're there, the more you find your niche and you specialize in a certain area. And the work we do in a funder is a bit more broad. So it's not necessary that you are super specialized already. So I would say anything between 2 and maybe 5 years is certainly very helpful. But I'm also not saying that's necessary. You should never, there's no point in applying if you haven't worked in a law firm before, because also, for example, in-house experience can be helpful. We have an excellent case manager who joined us straight after the bar exam, so without having worked as an attorney, and he's doing an amazing job. So we also, by the way, quite often have students working for us, or we offer internships at times for people that just finished studies. So, I mean, there, as everywhere, different career ways to get to us, but it's certainly helpful. And then an LLM, for example, it's certainly not mandatory, but it's quite important to be rather fluent in English, because we have cases from a lot of jurisdictions. So we work mostly in English, or a lot in English, and any additional language, of course, is a plus, given the different jurisdictions we work in and the cases we see. And then I would say a bit of a soft spot for numbers and financials is certainly not wrong. I mean, it's not rocket science what we do. You don't, need to be super good in math, but it's certainly good if you not completely dislike numbers, I would say.
And perhaps one last question before we turn again to the audience for questions. Now you are in a third-party funder. What are the career opportunities for your profession? And also, how easy or difficult is it to go back to a law firm if you come?
Yeah. Well, first, the career opportunities. I think, as I mentioned, hope it's a growing industry. So I think there will be more funders entering the market. I think the funders will grow and get bigger. So they will probably have, subdivisions, and there's the chance of having responsibilities for new markets or new product lines. For example, it could be responsible for portfolio fundings, things like that. So I think there are a lot of opportunities within the actual third-party funding industry. And then I think, and well, maybe I addressed the question, can you go back if you worked at a funder, back to the law firm? Well, after a short amount of time, certainly, because you also gain a lot of, you see a lot of work products from different lawyers. You get experience of a lot of cases. It might get a bit more difficult after a lot of years, because, as I mentioned, at least in the big law firms, usually you get specialized after a while, and you kind of lose a bit the special. Or maybe in a bigger funder, as they grow, if you only look at competition cases, I think it would be no problem going back into working competition law. But I think it might get a bit more difficult if you worked for, I don't know, 7 years at a funder to go back. But what I think is that having work experience in third-party funding can be extremely helpful for other in-house positions in companies, because those commercial and strategic considerations you learn to do working for a funder or at least should be, in my view, very interesting for companies as well, because that's what's important for them. So I think it helps, or there can be opportunities outside of funders as well there.
Okay, that's good to know that you can always go to other places as well and keep your options open. Are there any other questions from the audience? Yes, Rupa?
So what I gather from what you said, Olivia, is that fluency in English is definitely an asset for a third-party funder.
Yeah.
So would it be fair to say that it doesn't really matter in which jurisdiction you're qualified? It's more about the skills that you bring with you? Or I mean,
we do have a different office at Nivalion. We have different offices. We have one in Vienna, Austria. We have some in Germany, and of course, for case we have people qualified in that jurisdictions, mostly in those offices. And so if we get a case from that jurisdiction, for example, Swiss cases, we of course do a lot less rely on the work of external specialists, because if we are very familiar with this national law or this area of law, we don't need to rely that much on external specialists, which costs money. So, I mean, to a certain extent, we certainly need people qualified in the areas from where we get a lot of cases. But then we always look, we can't have, you know, lawyers qualified in every possible place. So we always also look at cases from jurisdictions where we do not have lawyers qualified in that jurisdiction. And there it's, as you mentioned, in general, more important that we have people who are good in getting a big picture of the case quickly, who are good in, you know, spotting red flags. And then we can always, if you realize that's the crucial point, but you are not qualified to, you know, decide on that on yourself, we can then mandate someone who looks at that specific question. So I would say, in principle, what you said is absolutely true. Yeah, it's more important what skills the person has, and yeah, then to be qualified in a certain jurisdiction. Absolutely.
Thank you. It's a very interesting difference from law firms.
Yeah.
Are there any other questions?
Yes, I have a quick question. Thank you, Olivia. It was very interesting, your presentation. My question is related to the KYC process. I would like to know if you do it the same as the banks do it, and if you perform the KYC internally or you have external service providers to do that.
So far we do it internally. And I think it's probably less requirements. I don't know exactly the requirements of the bank. I'm just, what I know is that they have rather strict and a very formal process. So it's a bit less. What I mean for us as well, it's of growing importance, especially if you think about, you know, sanctions. So you need to know who are the people involved in the cases who are behind that. So I would say we do have, of course, strict KYC requirements, but I would say less strict probably than banks. But it's something that might change and get even more strict in the future.
And would that be part of your task to do the KYC, or is it someone else that would do it as a case manager? If you are the case manager.
To a certain extent, in the sense that you are in touch with the claim holder and the attorney, so you request to get this information that you need. But then it can be someone from the back office who does the, you know, handles this information.
Okay. Okay, thank you.
You're welcome.
Yes, Natalia.
Hello, can you hear me all right?
Yes, we can hear you.
Thank you very much for this super interesting presentation. I've got a question about like the markets you're operating on, because you mentioned Vienna as one of the offices, and I was wondering whether you have quite a lot of clients or like a lot of cases being funded from London and from the UK jurisdiction. The reason why I'm asking is I'm a trainee in the London office, currently on secondment, but that's irrelevant. And we were recently approaching some funders, and I mentioned Nivalian, and it wasn't so much well known among the people who are making the inquiries. So I was just wondering what's the position on the London market?
That's actually, I would say, what the scope, Nivalian scope, is most jurisdiction in Europe, the Americas and Asia Pacific, but we basically exclude UK just because they have so many funders there already. So funders have such a strong presence that, I mean, if we would get approached, we of course look at the case, but it's not a market that we basically go and try to be present on, because they have such like long-lasting connections and experience with funders. We kind of feel like if we would be approached, it's mainly other funders had turned down the cases already, because it's more common, you know, for the law firms to approach those funders that they already know and work on this market. So that's why we are, as you correctly experienced, really not strongly present at the UK market.
Oh, makes sense. Thank you for this explanation. Thank you very much.
You're
Maybe
welcome.
in the future.
Yeah, and of course, if we get approached, I mean, we're happy to look at the case, but it's not where we define internally that that's our, goal to become present there.
Makes sense. Thank you very much.
Okay, so if I recall correctly, how are we time-wise? Paula, do we still have some time, or should we wrap it up?
I think we should start moving towards wrapping it up, unless one of my colleagues has a different viewpoint.
Okay, so yes, let's wrap it up. Thank you again, Olivia, for this very insightful interview. I think we all learned a bit more about what it's like to work at a third-party funder, and also about the opportunities that it offers. And like in the first session, we also learned once again that sometimes the opportunities come when you least expect them. So with these last words, I would like to give the word back to, I think, Konrad.
Yes, thank you very much to both of you. On behalf of Swiss VIAP and Young Arbitral Women Practitioners, thank you for your great insights and for the interesting questions. And thank you to all of you for taking part today and for asking your questions today within the session and also in advance when you registered. It's been great to have you all of you here during this event. As you know, today's event was part of a larger series on career path and arbitration, and we have 3 more sessions in this series coming up. So on 5th of October, Angelina Petty of Fonseca Law Offices will explain how to build an arbitrator practice. On 15th November, there will be a session on starting a boutique law firm with Simon Gabriel from Gabriel Arbitration. And finally, on 7th December, Annabelle Mökesh from Implenia will tell us all about going in-house. These sessions all take place at 1 p.m. and they all take place here on Zoom. So keep your eyes open on our LinkedIn page and on our website for the registration. And we look forward to seeing you there. And for now, thanks again a lot to Olivia and Francesca, and have a good afternoon, everyone.
Thank you all. Thank you for your interesting questions. Have a good afternoon.
Have a good afternoon. Bye.